Yeah, so the question is the executive obliged to lay executive instruments before Parliament for it to validly come into force. So as we've indicated not long ago that this question is part of sources of law and is relevant, especially so when you pay attention to the decision of the Supreme Court in the case of Association of Finance Houses against Bank of Ghana and Attorney General, decided in 2021. And the brief facts of that case, insofar as is relevant to sources of law, is that the Bank of Ghana actually issued corporate governance directive. And the corporate governance directive was supposed to have been issued by the Bank of Ghana in exercise of provisions of a legislation known as banking and other special banks and special deposit taking institutions act 2016 act 930, and that legislation per section 56 and 92 stated that the Bank of Ghana can actually make rules or come up with the necessary directives which will advance corporate governance within the banking and the financial sector. Now, the plaintiff in this case, that Association of the Finance Houses, they wanted to challenge the legal validity of this corporate governance directive, because in their view, if you look at the provision under which the Bank of Ghana was able to make that directive, that provision was under a particular legislation, as I have mentioned, the Banks and Specialized Deposit Taking Institutions Act 2016 Act 930. And I want to just read the wordings for you. So if you look at section 56 of that legislation, this is what it's stated. Let me show it briefly for you. This is what is stated. Okay. Yeah, so if you look at it, the section 56 of the Act 930, this is what is stated. I quote, the bank may prescribe rules regarding any matter of corporate governance of a bank, specialized deposit taking institution or financial holding company that the Bank of Ghana consider necessary or appropriate to A, ensure prudent operation, and so on and so forth. So the essential thing is that section 56 says that the Bank of Ghana may prescribe rules, okay, regarding the matter of corporate governance. Now, and again, if you look at section 92 of that legislation, it also stated that the bank may issue directives to banks, specialized deposit taking institution, or any financial holding companies. Yeah, so the most important thing is that the bank may issue directives. So we've seen directives in section 56, and then we've also seen it in the, we've seen it in section 92 and section 56. Section 56 actually talk about rules, okay? And that the bank may prescribe rules. And then section 56 also say that the bank may issue directives. Now, we know that where a legislation is actually conferring power on a body or an entity to make additional rules, we call that delegated legislation. So one will argue that what section 56 is seeking to do, to the extent that it is giving powers to the Bank of Ghana to prescribe rules for corporate governance of banks and other financial institutions. It's like an example of a delegated legislation, okay? And then we come to the, the controversial one, that the directives, 92, that it may issue, directives in respect of any of these matters to ensure proper management of banks and so on and so forth. So, question which arises is this, that the rules which Section 56 of the Act 930 and also Section 92, the directives, which are supposed to be issued by the Bank of Ghana, are they legislative, instrument, or let's say that are they the kind of regulations, orders, or rules contemplated by Article 11, Clause 1C of the 1992 Constitution? If you conclude that they are, then what it means is that they must comply with Article 11, Clause 7. Article 11, Clause 7 says that orders, rules, and regulations made, right, under the Constitution are supposed to be gazetted and also laid before Parliament for 21 sitting days before it will come into force, if it is not annulled by Parliament. Good. Now, so that was the issue. And if you read the case, I think His Lordship, Justice KULENDI, went to town to try and look at the various scenarios and the various legislation in which directives, for example, are contemplated, and it will not necessarily amount to law. So he looked at the example from other legislation, and he concluded that if you look at the directives which were issued by the Bank of Ghana pursuant to pursuant to Section 92 of Act 930, it was essentially administrative in character and not legislative in character. Legislative in character will have meant that it was actually making rules, but administrative means that it is just carrying out some of its administrative functions. And for that matter, it was not intended by the framers of the Constitution that it will be amenable to the regulatory framework of Article 11, Clause 7, which will have required that it is laid before Parliament and also gazetted for 21 sitting days of Parliament. And so effectively, the court concluded that the directives by the Bank of Ghana on corporate governance are not rules, orders, or regulation within the purview and intent of Article 11, 1C of the 1992 Constitution. For that matter, it was excluded from the operation of Article 11.7, which says that no rules, regulations, and orders, be it a constitutional instrument, legislative instrument, and so on and so forth, should be gazetted before it will have validity. So let us keep that in mind. So I think that the rest are what you call like the consequential. Consequential in the sense that if it is not, if it is concluded that it is not an order, rules, or regulation within the purview and intent of Article 11, Clause 1C, then it is actually unnecessary to worry our head as whether it had to be laid before Parliament and gazetted. Yeah, so just look at that decision. So the takeaway is simply that where executive instrument is made, or a directive or anything made pursuant to powers conferred by a particular legislation, if that thing made does not have legislative character, okay? I think that is the test. If it does not have the legislative character, then it does not have to comply with the framework for exercising, the framework for controlling others' rules and regulations made under the Constitution or made under any particular enactment. So let us keep that in mind. Yeah, so that will end discussion of that particular question. And then let me see if there's any major question. Okay, so I think the other question I see before we come to what is the question? With regard to customary laws of Ghana as a source of law, will it be right? Will it be right? Let me see, I can see it well. Yeah, the question one student has put across. Okay, that's Araba. Now, with regard to customary laws of Ghana as source of law, will it be right to make reference to chieftaincy at Article 270 and the chieftaincy act, which allows for chiefs to legally carry out customary functions and duties? Okay, I think you are right, Araba. If you look at the Constitution, there is a provision that the National House of Chiefs, they have a responsibility to also see to what we call the systematic codification, okay? Systematic codification of customary law in Ghana. And of course, the hope is that at some point in time, if the National House of Chiefs and all that are doing their work well, especially if you look at Article 272, okay? Article 272 of the Constitution says, and I quote in paragraph, so the National House of Chiefs shall undertake the progressive study, interpretation, and codification of customary law with a view to evolving in appropriate cases, a unified system of rules of customary law, and compiling the customary laws and lines of succession applicable to each tool or scheme. And C, undertake an evaluation of traditional customs and usages with a view to eliminating those customs and usages that are outmoded and socially harmful. Yeah, so if you look at 272 plus B and C read together, you get another useful material for discussion of customary law. Yes, the Constitution has given our National House of Chiefs and then the various regional House of Chiefs a duty to help in the systematic compilation and codification of the customs of the various communities, and also try and ensure some kind of standardization, okay? You look at some of the minor variations, and then we can actually streamline it and say that maybe for the whole of Northern Ghana or for the whole of Ashanti region or the whole of the Volta region or maybe the Seychelles and so on, with respect to marriage, we say that these are the customary requirements, or with respect to this or that, these are the customary requirements. So it's all part of the work of the National House of Chiefs, but they've not made significant progress in that respect. If they have, it will make ascertainment of customary law relatively easier. Yeah. Now, you also mentioned Article 270. which was about the fact that the chiefs may carry out customary functions and duties, and you want to find out whether that particular provision is relevant when we are discussing customary law as a source of law in Ghana. Araba, I think that maybe the more relevant one would be the one I just quoted, Article 272, Clause B and C, regarding the duty of the National House of Chiefs to help in the systematic compilation and codification of customary law, and also in helping to outlaw customs and social practices which are considered as harmful. Yeah. Yeah, okay, I think this brings us to the end of the questions that people were able to bring.